Hello, my name is Karen Harding. I'm a criminal defence lawyer from New Zealand. I'd like to take this opportunity to share with you part of a draft I'm working on in a master's thesis. And this one is called Transforming Justice in Remote New Zealand. Chapter A, Embracing Non-adversarial Justice. The innovations of problem-solving justice, problem-solving courts, community justice, community mediation committees, alternative sentencing regimes and restorative justice processes, including sentencing circles and healing circles, have transformed justice processes in countries where these solutions have been adopted. This is non-adversarial justice. Embracing non-adversarial justice would transform the New Zealand justice system to be needs-based, people-orientated, forward-looking, more informal, collaborative, with emphasis on alternative dispute resolution involving a wide range of participants and stakeholders, where the role of the judge moves from arbiter to coach. It would enhance relationships with Maori. The judge would speak directly to a participant rather than just addressing counsel. The participant would engage directly with the judge. Problem-solving justice is a change from precedent-based processes. Problem-solving courts can enable participants to rebuild self-esteem as an outcome of a process that exhibits an ethic of care and provides treatment and helping services in a coordinated and efficient manner. The use of restorative justice in sentencing circles have a focus on victims and families, which allow for their needs to be met and provides more prospects for healing. An effective means of achieving transformation is to address the structural inequalities that Maori face by adopting plural governance in justice. It also requires mainstreaming problem-solving justice in traditional courts and in rural courts. This includes developing problem-solving courts to meet the needs of Maori and community courts with iwi and whānau involvement, wellness courts with structurally appropriate, culturally appropriate programs, and integrated service delivery systems would advance individual, whānau and community well-being. Transformation involves embracing alternative sentencing regimes such as sentencing circles, healing circles, and community mediation committees. This would provide a justice system with a focus on equity, accountability, subsidiarism, inclusiveness, restitution, and treatment. It is also consistent with the 9 principles of good governance as identified by the United Nations. The New Zealand Ministry of Justice in 2012 acknowledged significant transformation is required. It is seeking to create a customer-focused ministry, enabling people to resolve more issues without recourse to the courts. However, the current Ministry of Justice transformational plan is to close some rural courts and to reduce services to others based on a desire to achieve cost-cutting. Closures remove the symbol of a town's justice system and reduces access to justice for people living in remote areas. The resolution of Maori historical grievances through the treaty process provides an alternative opportunity to build on the improved relationships with iwi and the Crown. This is a pathway for more collaboration in justice and social policy for enhanced social cohesion, if the Ministry of Justice engages with Maori to include them in justice processes and policy making. The solution for empowering a community riddled with crime and social problems such as Apotiki is to embrace new governance in the justice sector and to increase services. The most effective and efficient way to reduce crime in Apotiki and Te Ura is to identify the prolific offenders, those offending due to social distress, addiction and substance abuse, and to target family violence by delivering the services of a problem-solving court with an alternative Indigenous sentencing regime to resolve issues underlying offending. Improving community safety requires reducing the precursors of crime and opportunities for offending. It also involves increasing the prosperity of those in deprived communities by improving the health and well-being of offenders, victims and their families, and by providing assistance with treatment and training. More emphasis on youth justice and families is required. Another tool is to expand diversion opportunities, restorative justice, the use of behavioural contracts and mentoring. Marae-based diversion opportunities and initiatives need to be available for adult Maori offenders in Apotiki. The use of a marae in the eastern suburb of Christchurch after the earthquake worked well in the adult criminal court jurisdiction. The temporary-based marae court was well respected by the defendants, who appreciated that the court came to the community and were observed to exhibit a sense of pride in the court. A 2006 report considered there was a need in New Zealand for community justice centres offering a range of facilities linking justice to the community. Rather than reducing services in Opotiki, services should be increased to specifically target problem areas as identified by a community advisory committee that includes local iwi and other stakeholders. A plural governance community court model is proposed for a revamp of the Opotiki District Court to meet the justice needs of Maori in Opotiki. Thank you.